Good afternoon, Bo. Here we are again. Thank you so much on our J-1 physician series. Today is our third talk. Very interesting. Legal notice. Today we are Angela Lopez with Cowles Thompson and my colleague
Michelle Alonso. Thank you for having us.
Great. So let's start. Always the housekeeping, please. The great thing about seminars or webinars or these presentations is that you can enter your questions. There's at the bottom of the screen, you're going to see there's a little icon that says chat. Feel free to type your questions as we do the presentation. And at the end of the presentation, we will answer your questions if we didn't get to do that during this time. Always be mindful, this is just a general information. This is a disclaimer. Do not rely on the information here to apply to your specific cases because it might have variants that might not be contemplated in this information. If you need to talk to us, please feel free to call us and we'll be happy to schedule a time to assess or respond to any questions you might have. So with that, let's start.
Excellent. So if you've been following us, I hope this is your third time with us because we've been doing a series for J-1 physicians specifically. If you haven't had a chance, I'll just put the dates up. You'll see them on your screen. We did one November 9th, understanding the 2-year home residency requirement. November 16th, we talked about J-1 waiver options. So those two presentations are available on YouTube. Also, so you can go back and view them. If you have any questions about those, contact us. And today, obviously, we're doing the presentation regarding understanding J-1 waiver obligations. And if you want to continue with the series, please join us and register for the December 7th presentation we'll have regarding green card options. So a brief recap, in case you weren't available for the November 9th, understanding the 2-year home residency requirement was what we discussed. And basically, you're talking about after residency or fellowship training is completed, the basis of that J-1 is going to require, it is in for, and it's required for all ECFMG J-1 physicians that you will return to your home country for at least 2 years at the end of the term. Now, home country, you'll see is defined there. It's a country of last citizenship or permanent residence. So look at the visa. We always look at the visa. So again, all the details regarding that was in our presentation previously on November 9th. There's the recap, but you're probably here because you're an ECFMG J-1 physician and you want to know about your waiver options and the 2-year home residency requirement obligations. So here we are, November 16th, we had gone over the 2-year residency requirement and talked about the different waivers, and you'll see those listed there. If you haven't had a chance, we discussed hardship waivers, persecution waivers, and then spent a lot of time on the IGA interested government agency waivers that you see there. Oftentimes, this is where our physicians are falling, is in that IGA category. To bring you up to speed for today's presentation, we're going to be understanding what that J-1 obligation is about. You'll see on the next slide, it's just going to be a brief overview of where we are in terms of the series and what we're going to be touching on. But you'll see there all the requirements listed. Basically, once you're in J-1 waiver, you have to serve that J-1 waiver in H-1B status for the full 3 years. Physician must work full time, and we'll go into that as well. The physician must be an employee, and that's key, employee of the sponsoring employer. And an employer and physician must submit periodic reports to state or federal health agency. I know Angela's going to touch on that as well. And you don't really change employers, at least in this stage of the game, unless there's a situation regarding extenuating circumstances, and we will talk about that in this presentation. And again, the physician, you cannot become a permanent resident until you've had the J-1 waiver completed and the time served and service was done according to the terms of the contract, which we'll see is about 3 years, which is 3 years.
Okay, well, that being said, so let's start. The first obligation, and here is what we're talking today. Obligations, J-1 waiver physicians, and your waiver and your obligations are the following. The first one, it is physician must work in H-1B status for full 3 years. Why? Well, the J-1 waiver is just the authorization for the physician to stay in the United States. As Michelle just mentioned, a little recap. When you have a J-1 visa, ECFMG, you have to go back, or you're required to return home or last place of residence upon completion of your training. To stay in the United States, you need a waiver. So once you get the waiver, that is, you don't have to go back home. You can stay in the United States, but the J-1 waiver is not work authorization. To work in the United States, to meet the J-1 waiver obligations of working full-time and all these things, the employer who sponsor your J-1 waiver must file an H-1B visa application upon approval of the waiver, or upon the Department of State recommending the waiver. The J-1 waiver in general goes through 3 different agencies, and we talked about that last week. The Department of Health, or the intergovernment agency, Veterans Affairs, one of the other programs, the Delta, the ARC, or the newest program. Once that agency approves the waiver, it sends it, or recommends it, sends the application to the Department of State. And then the Department of State decides, yes, normally they follow the DOH. I have never had, or we have never had a situation where the Department of State says, no, we're denying it, although the Department of Health approved it. I have never had that. But once the Department of State approves it or recommends it, sends the petition to the Department of Immigration for final approval. You might file, if you're running out of time and you don't have the time to wait for the Department of Immigration to send that final approval, the I-797 notice, which is the I-612 J-1 waiver approval, then you might be able to file the H-1B visa application with the Department of Immigration with the letter of recommendation from the Department of State. And the purpose is that you can get that H-1B visa approved soon enough so you can start working at the end of the training program, and you won't have to go out of the country to wait for the H-1B to be approved to return an H-1B. So H-1B visa must be filed. The H-1B application must mirror the J-1 waiver because they go hand to hand. So if the J-1 waiver says you are going to be working with a specific employer for 3 years, the H-1B visa must have a term of 3 years with that specific employer that sponsors the J-1 waiver. You can't just take your J-1 waiver approval and go and work for somebody else. USCIS will not allow that unless extenuating circumstances, and Michelle will talk to us about that later. Must be full-time employment because that's what the J-1 waiver requires. And the J-1, the H-1B must specifically state or outline each location or the location you're going to be working for the full 3 years, which must be consistent with the location or locations that were listed and you were listed on the J-1 waiver. Sometimes employers try to add a location here or change a location there. Be careful with that. We have heard reports the Department of Immigration is being a little bit picky about that, and they have been questioning H-1B visa applications when they are not mirroring the J-1 waiver in terms of work locations, because sometimes those changes might be justified, but be mindful of that. Just be also one thing from this, if anything you're going to remember from this slide here, is that the 3 year J-1 waiver clock starts on the first date of employment. This is key because we do have consultations with physicians frequently, and they many times bring up, well, my H-1B was approved on July 1st, but I didn't start working until August 1st. But they start counting the 3 years from July 1st, and they're missing the whole 30 days because they never start working on July 1st, but August 1st. You start on August 1st, which is the first date of employment. So from there is the 3 years, and it's full 3 years, not 11 months or 11 months and 29 days. Physician must work full-time. What full-time means? Well, for purposes of the J-1 waiver, full-time means 40 hours per week or 160 hours per month. We're mindful, and the agencies are mindful, that sometimes physicians work on shifts, especially hospitalists, 1 week on, 1 week off. But as long as the number of hours of medical services add up to 160 hours per month, they are okay, or 40 hours per week. It's providing the medical services that were outlined, what type of primary care, internal medicine, family, infectious disease, cardiology, whatever the services that were outlined in the J-1 waiver, that's what the physician is going to be doing to serve the underserved population, because that's what the area where their work location is and was provided in the J-1 waiver application. Some administrative duties may be considered. Actually, the agencies are pretty good. They understand that 40 hours of strict client service is kind of impossible, because you also have to do charts, make notes, and other things that are consistent with providing care for clients. But we have agencies, or certain states, other agencies, that they sometimes say, well, okay, as long as you provide 32 hours of medical services a week and 8 hours of additional other services, but they are very specific as to how many hours. In general, the requirement is 40 hours weekly, or 160 hours per month, and that's the full time. We know with physicians, 40 hours a week is nothing. We know that physicians usually work 50, 60, sometimes more hours, same as more than 160 hours. So 40 or 160 is nothing out of what can normally be accomplished, but that's the minimum requirement. Moonlighting is possible after meeting the full-time, the 40 or 160 hours. We do have and help physicians frequently to file concurrent H-1B visas to work part-time with other employers, besides or in addition to their primary obligation, which is the H-1B based on the J-1 waiver. Physician must be employee of a sponsoring employer. What that means is, for H-1B purposes, there's have to be a relationship of employee-employer between the physician and the sponsoring employer. That means it's a W-2 employee. It's not a 1099, which is a contractor. You cannot be a contractor, locum tenens, you can't. You have to be employed, you have to be on payroll, you have to get a W-2 and it's monthly or weekly or whatever salary, whatever system that is used to pay the salary, but as an employee of the company. If changes are made to the employment during the 3 years of the J-1 waiver, remember, we always have to go back to the J-1 waiver application, because the H-1B must mirror the J-1 waiver petition. Therefore, any changes to that employment during those 3 years, and we're talking substantial changes. It's not like, oh, I got a raise in my salary and now I'm making $20,000 more than last year. That's not substantial, that's just a raise. But if you're talking about, we're changing job locations, you're not going to be providing this medical service, but we're also doing something different, then that might affect your J-1 waiver compliance. So any changes, first of all, talk to your immigration attorney to make sure that the changes are not going to affect your J-1 waiver compliance. And second of all, if they might be possible, that a new H-1B visa be filed with the Department of Immigration to amend the terms of the visa that you're already working under, so that there is no doubt that whatever changes may have happened or might be happening are in line with your J-1 waiver obligations. We mentioned before the concurrent employment. It is possible. The concurrent employer must file an H-1B visa application before you start working with that employer. The concurrent work location can be in a non-underserved area. So you are required to work in an underserved area for purposes of your J-1 waiver. But if you're going to be working part-time for a different employer somewhere else, then that work location may very well be in a total different area and not have to be underserved. Concurrent employment can be part of part-time or full-time. Believe me, I know how many hours physicians work, and 1 week off, 1 weekend on. We have physicians who during those week offs, they work the full week with somebody else so that they can have 2 full-time employments. My heart goes to them because I don't know how they do it or how they survive. Most commonly is part-time, few hours, and usually it's a range of hours. It might be from 10 to 40, 20 to 30, 20 hours, 50 hours is the common use for concurrent employment. But it has to be under the authorization of the Department of Immigration based on a new H-1B sponsored by the new employer. Michelle?
Yes, so once we have the employer and physician must submit the periodic reports or state to the federal agency. This isn't across for all states, right? It just depends on your jurisdiction, whether or not you will be required to report. Obviously, when we're going through the J-1 process and subsequently the H-1B, we will know beforehand whether or not your state or the federal agency requires those reports. So just keep in mind that is something that will be required of you and the employer when you're going through the H-1B time for your J-1 waiver process. It can be once a year, it could be every 6 months. And what you're going to be looking at is the employer and employee attesting to the J-1 waiver compliance. So all the terms that were in the contract for the J-1 waiver that, as Angela mentioned, will be mirrored on the H-1B. They're just coming in and double checking, and they want to make sure that you are, in fact, like Angela mentioned, an employee, you haven't been moved off to contractor status, that you are going through with the 3-year obligation, that your hours haven't been cut off, that you are meeting full-time employment. And the most critical is that the work that you're doing and the areas you're serving are in those designated underserved areas. So it's one of those things where you'll know regarding the program and the jurisdiction that you're in, if you're going to be subject to this periodic reporting during the J-1 waiver time and service in H-1B status. So what we're going to discuss next is when can a physician change employers? And we mentioned at the outset, and this is where we're going to go into it, extenuating circumstances creates and allows for that exception. This is where there's unforeseen circumstances that are outside of the control of the physician. And basically, we're going to USCIS and oftentimes the agency is saying, look, I have to change employers. As a physician, I can't carry out my duties because, and it all amounts to extenuating circumstances. So what might that include? And you'll see here over the next couple of slides, these are situations that our office has handled in terms of these extenuating circumstances to transfer employers, personal hardships, medical issues, such as family separation. We recently did one where the family separation was the issue. No one could have anticipated it. But the child in that situation was primarily living with one of the parents and not the physician parent. And the commute, the expense, the treatment that the child had to go through as a result of this hardship, all was documented, and we were able to successfully get that physician transferred. Work location closure by employer. This happens a lot. Sometimes where you're working, they don't run the business and the location has to close. Well, you're bound by the terms of that contract to be serving in that area, at that clinic, at that address with that employer. If they close locations, well, wasn't your fault, right? Breach of contract by the employer. I mean, there's still contracts in place. And so in those situations, we've worked in tandem with and in collaboration with the employment lawyers who are working with the physicians because there's a breach of contract. We stick to our lane, we stick to our area of the law, we handle the extenuating circumstances transfer, but oftentimes we might be part of a team because the situation calls for it. Employers' failure to pay the physician the prevailing wage, that one's the easiest. It's documented. You're not being paid under the terms of the agreement. The H-1B requires a certain wage. The J-1, those terms are outlined in the contract. If they're not meeting their obligations, those can present extenuating circumstances. So a few more examples of cases that we've had. Let's see, racially or sexually discriminatory practices. I mean, in this day and age, employers are different and some allow for certain cultures. And so that could be a situation that comes up. We've had it come up and again, it's documented, we're able to successfully secure that transfer. Employment requirements that would not allow the physician to practice medicine in an acceptable manner. This one's tough. This one is definitely, again, goes back to documentation. We talk to our physicians about, as Angel mentioned, how many hours are they working? Are they exhausted? Are they having to get treatment? Are they sick? Are they asking the biggest one? Are they asking you to commit insurance fraud? I mean, we've had cases where there's been text messages that said, you didn't code this way. Right there and there, we have an issue, and the physician, you can go and say, look, I can't sign off on this. I can't do this. You're asking me to commit fraud. And certainly those rise to the level of extenuating circumstances, but it is important that those are documented. So Angela and I have both submitted cases with text message screenshots. A lot happens through text message, believe it or not, or pictures of message exchanges through the internal system that the office uses. So this evidence can come in all sorts and forms, again, must be documented. So let's see, a few more. Oh, Angela, you have some comments? You're muted.
Yeah, I'm sorry. So speaking of documenting the extenuating circumstances, and we do talk and consult physicians all the time about these, as well as some employers, because sometimes it might be a misunderstanding. But the key to being able to change employers during those 3 years of commitment because of the J-1 waiver, and be able to demonstrate, because it is on the physician to demonstrate the extenuating circumstances, unexpected circumstances that you couldn't have seen coming, and it happened, and I have to change employers. So documenting. Michelle just mentioned, keep copies of those texts, the emails. When you have a conversation with somebody about the problems that you might be facing, verify or confirm or go back, send an email to all the respective parties just to make clear, per our conversation, this is what I understood. Believe me, we do this frequently enough to know that many times when conversations happen and an email is sent, people realize that maybe things were taken out of context. And some problems can be resolved right there in there. So because the Department of Immigration wants to see that information, that documentation, specifically because one of the things that they have said in the past is yes, you might be going through extenuating circumstances. Yes, you might have these. Did you give the employer a chance to resolve the situation? If you're coming and you say you're having all these issues, did you tell the employer? Did the employer know you were going through this? What happened? You talked to the employer. And sometimes we have people who come and say, well, I haven't really talked to them. Well, start there, because we have seen enough cases where employees bring up all these concerns, valid concerns, and we have seen how many times employers, good faith, they change things and things go back to the normal relationship, and things can be fixed. But USCIS want to see not just the proof of extenuating circumstances, also that you did try, hey, this is going on, this is wrong, I can't do this, communication. And if the employer doesn't do the part, well, then you have enough case. If you have enough evidence and a strong case, you go to the Department of Immigration and you lay down your case. Not only this is happening, but I did try. So documentation of extenuating circumstances, compelling reasons. What is it? Text, letters, phone calls. If you have colleagues going through the same situations, get letters from them. We frequently hear from clients saying, well, I had so many physicians that already left the practice because they couldn't do this. Get letters from those people because they will validate what you're going through. They will confirm that. Also, if the situation is too extreme, many times we recommend physicians to hire their own employment lawyer. Because this is not only J-1 waiver, H-1B, immigration issues, compliance, but it also may involve employment and labor law issues. And that might be part of how you can document the hardships you're going through in trying, or the circumstances that warrant the change of employer. A letter of release or support from the Department of State or the respective agency saying, yes, you can change employers is not necessary. Although we have certain agencies that are clear in saying, if you're going to change employers during the 3 years, this is the procedure. You need to send us all of these things so we can allow you to change employers. Well, really, the agencies at that point don't have much to say. It's up to the Department of Immigration to grant or not the H-1B based on the extenuating circumstances. I do very few times have file papers with the state for them to allow the change of employer, only when I know the physician is going to stay in the same state, because you want to be in good terms with the state. And so if you're going to if you find employment in the same state you got your J-1 waiver, well, maybe you should let the Department of Health know, hey, this is what is going on, I'm changing employers. But just as a courtesy, not necessary, not an obligation, because at this point it's up to the Department of Immigration. The more evidence, I'm sorry, this thing keeps going crazy, but I'll try not to move too many buttons here. So the more evidence you can gather, the better is, because it's how strong your case might be. You want to file a strong case so that the Department of Immigration has no choice but to approve it. If they don't approve it, well, you're going to be stuck with the other employer for the 3 years. It's not that if they don't approve it, then you lose your other H-1B. No, you have your H-1B. And many physicians, when they're going through this, you don't have to let your current employer know about this. You go ahead with your other employer, make them aware of what's going on. Worst case scenario, USCIS says, no, well, they're stuck. Otherwise, you're going to have to go home. But they will not revoke your present H-1B. That's the norm. Physician cannot become a permanent resident until J-1 waiver services is completed. Michelle explained very well. The 3 years, you have to meet the 3 years compliance. We talked about that last week. We mentioned this before. It's full-time, 3 years, 40 hours, and those type of things. So once you complete those 3 years, you can get your green card. You must demonstrate that you completed the 3 years. How? Again, we don't need a letter from the agency that grant the waiver in general. Some physicians go to the agencies and they get those letters. Great, we'll use it, but we don't need it. In general, what you will need is a letter from the employer attesting that, yes, physician start working with us and on this day, and he's been working with us 3 years, doing this, no changes. Tax returns for the last 3 years, pay stubs and W-2s, and that shows that you were in fact working with that specific employer in that area in compliance with your J-1 waiver, and then you can complete your green card process. And green card process is something we're going to talk about next week. So now we're going to questions, and there are a couple of questions in the chat. I think we have been answering some of the questions, but I'm going to review the questions so everybody can hear. The first question was, can you get us the links to the previous presentation? Michelle already posted it on the chat, so hopefully you'll go to our YouTube channel to view the videos. Who define underserved areas? The state. They, based on demographics, statistics, and other things, they define what are the underserved areas. And we're talking underserved areas, not cities or counties. Be careful there. It can be deceiving, right, Michelle?
Yes.
For example, in Dallas, we have one side of the street is underserved, you cross the street and the next one is not.
Yes, precisely. So you want to double check the website and put in the physical address, because in metropolitan areas, there will be pockets of underserved areas next to very metropolis and affluent sections of the city. So, and just because something is rural, you need to confirm that address. So yes,
Correct. Don't just assume
yes.
that if somebody says, well, Dallas is an underserved area, don't just assume that the entire county it is. There might be pockets, like Michelle says, that are not. The state defines the underserved areas. You might check the status of the underserved area in the HRSA, Health Resources Services Agency. There's a website there where you can enter the address, and it will tell you whether or not it is in a health professional shortage area, or medical underserved, or health, mental health, medical underserved, or if it meets that. Concurrent employment, there was one. Yes, the new employer or the concurrent employer must file an H-1B. That's a given. You cannot work. The H-1B only allows you to work with the employer that sponsors the H-1B.
Precisely. The H-1B is not employment authorization that you can go work for an employer. It's specific to that employer and employee relationship with those duties, which is why you would need that second employer for concurrent employment to file that petition.
There's one question here about, are the employers fine to terminate a J-1 waiver worker for no fault reasons? And then does the worker have to start the 3 years all over again with a different employer? You want to tackle that one, Michelle?
So this is where I touched on, there are clauses in your employment contract that you will submit with the J-1, and those contracts are also turned into the H-1B. We always advise the physicians to review those contracts with a labor and employment lawyer, because those terms often are defined by state law, or sometimes the terms will be nestled into these employment agreements. So most states, if not all, are at will. So technically, if they're going to terminate you, they're going to terminate you. It's without cause. It's an at will employment. But in cases or situations where there's contracts involved, you want to make sure that you understand your position in terms of the contract for a breach of contract or a labor and employment claim.
Also,
that has nothing. Yeah.
Also, most, not all, of the agencies and the state do require that the employment contract do not include clauses that permit termination of employment without cause. I frequently have to tell employers, you need to remove that, because according to the guidelines, you cannot have a termination without cause. However, like Michelle says, that doesn't prevent employers from terminating the employment. And if they terminate it for no fault, first of all, termination cannot be, oh, upon our agreement, we are hereby terminating your employment. You cannot agree, because that's not extenuating circumstances. If the employer comes to you and say, I'm sorry, we cannot continue to employ you because of revenue is not enough, because we're going to have to close the clinic, because whatever circumstances, here is your letter and you have 30 days to leave. Fine, that's extenuating circumstances. We are terminating you because we don't want you to work with us anymore, but not fault. If there is termination for fault, you're going to have issues in trying to change employers unless you can demonstrate that it really was not your fault and have the evidence to support that it was just the employer, but was not your fault. So yes, they can terminate in general, give you the letter and goodbye. That will be extenuating circumstances. Following that question, there is an additional question here that says, that asks, can I terminate the waiver work if I am not happy with or just not a good fit for me? That's it. No, 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 no. We talked about extenuating circumstances, and Michelle gave you pretty good examples. This is not about whether I like the employer or not. This is about you committed with the federal agency or with the state agency that you are going to work in that underserved area for 3 years. Whether you like your employer or not, you must comply with the 3 years term. That's why it's important to visit those work sites, to have the interviews. It's difficult. I always said that when you do an interview of half an hour, or you go and visit a place for an hour or for a day or for half a day, anybody can be at their best behavior. So you really don't know what you're getting into until you are there. But just on the basis of, I don't like them, I don't like the place, or they're not paying me enough. Remember, you signed that contract and you knew how much they were going to pay you. So those are not reasons to terminate an employment. That will never be extenuating circumstances. And we have one doctor here that posted the HRSA website. Great job. Thank you for doing that. I didn't have time to Google it, but you did great. Can I change employers to another employer in the same city? Both are underserved areas. My job asked me to manage ICU patients that they told me I am not managing before signing the contract. I'm not completely sure what the question is there. You can change employers, like we mentioned, right? Extenuating circumstances, no problem, if you can prove it. You can stay in the same city, yes. Most employment contracts, because the agencies require, must not contain non-compete clauses. Few agencies don't care about it. So if there are non-compete clauses, some agencies don't care. They don't look at that. They don't pay attention. But if there is a compete clause, non-compete clause, you may not be working in the same city. But in general, if you are in the same city, you change employers, you can prove extenuating circumstances. There's no non-compete clauses. You can do that. I'm not sure about what they are asking you. If they are asking you to provide ICU medical services and that's not included in your J-1 waiver, I think we need to look into that more carefully. So call us. We'll be happy to discuss that with you. Can we have joint positions in other institutions? Is telemedicine also considered full-time? For J-1 waiver, Michelle?
Well, for J-1, again, you have to be serving in the area. Telemedicine is one of those situations that is just, it's not considered meeting the terms of underserved. And we've gone back and forth. And the government has in a couple instances said, the idea that you're in an underserved area, telemedicine can happen to everyone, anyone across the globe, across the country. You don't know that you're reaching necessarily the community that you're supposed to be serving in that area. I believe, Angela, there were situations where telemedicine was being allowed because the clinics weren't open during COVID.
And even now you can do an H-1B for telemedicine. So you could do the concurrent telemedicine H-1B employment or additional duties for telemedicine, but not as part of your J-1 waiver. Actually, one of the items for some of the agencies is that on-call time doesn't count towards the 3 years service requirement. Therefore, telemedicine kind of serves the same purposes. So not for J-1 waiver, you could do an H-1B part-time employment, concurrent employment, additional duties after you meet your medical services, personal services to the underserved population. Do we have any other questions, Michelle?
Yes, one just popped up. Just out of curiosity, what's the consequence if the employee quits before 3 years? This person saying their impression is that they'll just be subject to the 2-year home residence requirement again, but are there other consequences, anything more serious or egregious than that?
Yeah, quitting is not an option. You make sure you document your extenuating circumstances. You file that petition with the Department of Immigration to change employers. But quitting, you will put yourself in a difficult situation. Because remember, Michelle, the definition of extenuating circumstances, let's review it again.
Unforeseen circumstances beyond your control.
That you cannot, that you did not cause. Unforeseen, you didn't cause, beyond your control. And when you quit, that's your action. So you don't want to put yourself in that situation. Yes, safety is first. If you were going to die because the employer was going to, definitely quit, because that you should have a pretty good case. But other than that, you build your case, you file the petition, you change employers, and try to stay employed, because you will put yourself in a difficult situation by quitting and then trying to get a change of employer based on extenuating circumstances.
But the overall question, right? The idea is you're not meaning your J-1 to waive the 2-year home residence requirement. You may just go back home. And so you didn't have that 2-year home residency requirement waived. Rather, you just served it at home for 2 years.
Correct. Now, I know we got a couple of questions this afternoon before we start. If you want to read them, and we'll go.
Yes. I have to go on maternity leave. How does that impact, or how do situations with FMLA leave get, I guess they said, get figured into the J-1 waiver compliance time? So, for example, in this situation, if she was to take 12 weeks maternity leave, do those 12 weeks get deducted from her 3-year compliance, or say, is it 3 years plus 12 weeks that she'll meet, or does she get to count those within the 3 years?
Yes, that is you have to add those 12 weeks to the 3 years.
Precisely.
Not is 3 years plus 12 weeks. What is going to happen is that those 12 weeks are not going to count. So you will need to work an additional 12 weeks from the day you were anticipating to finish your waiver to be able to comply with the 3 years. The only time that is not discounted from those 3 years, or deducted, whatever you want to call it, is vacation time. So if you accumulate enough vacation time to have 8 weeks vacation, that's vacation. You don't have to make up for vacation time. Sick leave, be careful there. Many times there's paid sick leave, and that might be reasonable, but when you are taking sick leave, extended sick leave, that might not be that excusable. But FMLA, you'll have to make it up. Any other time off without pay that is not considered vacation, you will have to make it up to complete the 3 years.
And I had one other question that was sent in, which I thought was pretty relevant. Here it says, for some employment, 35 hours is considered full-time. Is it 35 or 40 hours?
It is 40 hours. Why? Because the agencies require 40 hours. Exactly. Technically, the Department of Labor says 35 hours, or whatever the employer decides, may be below 40, but the agencies have been clear. They require 40 hours or 160 hours, and that's the waiver. Yep. Like we mentioned before, some agencies go into how many hours is considered full-time, 36 hours, 38, 32, you can do so many other hours, administrative duties, and blah, blah, blah. But that is on a case-by-case basis. Overall, and in general, you're looking at 40 hours, 160 hours, and that's what the agencies require, so you are in compliance with the J-1 waiver obligation. I think that was it, right, Michelle? Is there any other?
Those were the two from earlier today, so yeah, that should do it.
Well then, oh gosh, I keep doing this. Well, thank you so much. We appreciate your time. We enjoy doing this presentation so we can all learn. And next week, there's one more final. Thank you so much. You are very welcome. We'll see you next week, Wednesday.
Yes, please don't forget to register for the last of this series. And Angela, I believe we'll be posting this also on our YouTube channel. Normally we go live. We had a little difficulty there, but You'll see that along with that series that we posted the link in there.
In the stream today, but next week we'll be here talking about green cards. You don't want to miss that one. Thank you very much. Have a good night.
Thank you.